Good evening, ladies and gentlemen. Welcome to TechGig webinar, our endeavor to empower techies. We believe that sharing of knowledge is the key of enhancing our performances and for our growth as professionals. With this principle in mind, TechGig has initiated a series of webinars conducted by industry experts to give a crisp insight of various domains. Topic for today's webinar is Copyright Compliance and End User License Agreement. We are delighted to have Mr. Tarun Khurana, Partner and Patent Attorney at Khurana & Khurana Advocates and IP Attorneys with us today. Tarun has over 9 years of experience in a broad range of intellectual property subject matters. Tarun has executed numerous assignments related to exercises of patent portfolio creation, protection, valuation, and commercialization for corporates ranging from small startups to Fortune 5 companies. Tarun focuses on the patent preparation, prosecution, and litigation opinion for computer-implemented electronics and mechanical subject matters. Gentlemen, this presentation will continue for next 45 minutes and we'll take your questions after the presentation. In the meanwhile, you can post your queries through the chat pane available in the webinar software. Without further ado, I introduce you to our guest speaker, Mr. Tarun.
Hello.
Yeah, Mr. Tarun, we can see your slides. We can see your.
Yes.
Please go ahead.
Okay. Am I audible properly?
Yeah, you are very much audible.
Hello. All right. Perfect. I'll just start off. All right. Good evening, everybody. The topic for today is copyright compliance and issues related to end user licensing agreements, and I'll also be trying and covering, depending on the amount of time availability that we have, topics related to open source software. But the major agenda of today's discussion would typically be on what copyrights are and how software copyrights are to be protected, what kind of enforcements can typically happen for software copyrights. Now, as an introduction, copyright is one of the intellectual properties that is protectable under the Indian statute. Copyright is one of the very few intellectual properties which are, even though protected in a particular geography, give a protection for the entire set of geographies which are a part of the Berne Convention. Now, what I mean by that is copyrights, if filed in India and protected in India, by virtue of India being a member of the Berne Convention, the copyright eventually gets protected in all the 134 countries which are a part of the Berne Convention. So apart from that, other intellectual properties like trademarks or designs or patents for that matter, they are all territorial rights. So you have to go explicitly and go ahead with the countries in which you want to protect your work. But as far as copyrights, it's only one protection that you need, and you are protected for all the countries. What is intellectual property? Now, and what is copyright in specific? We've already discussed about intellectual property earlier this month in another session that I've already given. Copyright is a form of intellectual property which is given to any creator for an expression that is creative in any form. It could be either a literary work, it could be a book, it could be a movie, it could be a script, it could be any form of an expression. It could be a painting or a sculpture, any form of an expression which is creative, which is original. I mean, originality is the key here in terms of deciding which all works are copyrightable and which are not. It is a right which is given for a stipulated period of 60 years from the death of the author. So, for example, if I write down a book today, the life of the right, which is the copyright that I have, is 60 years after my death. What are the rights that I have? I have the exclusive rights to use my own work and stop anybody else from distributing, publishing, adapting, creating any kind of derivative work over and above my own copyright. any kind of reproduction, any kind of communication over my copyrighted work would be completely something that I would have a right over, and anybody else who wishes to work on my copyright would have to take a prior explicit permission in the form of an agreement from my own side. What can be copyrighted? It could be any work, as I said, which is creative in
Hello.
nature. It could be a literary, dramatic. Hello.
Your voice is breaking in between. We're getting feedback from
All right.
attendees also.
Okay. So is it better now? Should I speak a little slowly, maybe?
Yeah, and also please check your mic settings, etc.
I did actually check it out as well. Is it better if you could just help me out?
Yeah, it's better now. Please go ahead.
Perfect. So we were discussing about what all can be protected through a copyright. Now, copyright, as I said, subsists in for the complete life of the creator plus 60 years after his death, after which the complete work for which the copyright is given would become public domain and anybody can use it for any form whatsoever. Indian copyright dates back to 1957 when it came into existence. Prior to that, it was the British Copyright Act which was being followed in India from 1911 onwards till 1957. There were a lot of amendments which were made to the Copyright Act, one of which is also being very actively discussed, which is another forthcoming copyright amendment which is going to come on the lyricists and the creativity on the media side of the copyright work in terms of what rights are given to the creators, the lyricists, to the musicians, and to the producers of movies. Why should we protect our copyright? Copyright, as a matter of fact, is a right which is given as soon as an expression has been done in any form which qualifies for being original and qualifies in one or more categories like literary work or creative work or dramatic work. But copyright, once you write down a book or once we write down a lyric or once we draw a painting, we do not actually have to go explicitly to the copyright office and get it protected. It is extremely important to understand that sooner we express the copyright in the form of an expression on a tangible medium,
Your voice is not coming now.
Hello.
Hello? Yeah, your voice is coming now.
Hello.
Hello?
Fine. I will. Yeah. Is it better?
Yeah, it's better. It's fine now.
Okay. Perfect.
Okay, thanks.
I was discussing about what a software copyright is, and I was giving the definition for the moment. Now, software copyright is a type of copyright for software, which is essentially a computer program. So, what we get protection for in a software is the set of instructions, which not only include the source code itself, but also the database schemas. It could also include all the codes, all the structures, all allied and objective object codes or source codes which would typically form a part of a computer program. The copyright for a software not only protects the source code, as I said, it can even protect the screen display. So even a snapshot or a screenshot of screen of a computer would also be, if it is in terms of what is being displayed, uh, would also constitute as part of software copyright. Object codes in a binary part of the copy can also print the entire source code on a piece of paper and then put it across along with the legal forms to the copyright office, or we can put the entire source code on a compact disc or a DVD and also submit it either in the form of an object code or a source code on a CD and put it across to the copyright office again. This is an important case in the US because, as I said, case law or any litigation on copyright infringements that happen in the US, they would also be applicable to the Indian jurisdiction, and any decision taken there can also be abided by or put across to the Indian courts. Now, this was a very important decision that came across from a US Federal Circuit Court, wherein it was held that a computer program's structure and not only its literal code is also protected by the copyright. So it's not only the data structure, it's not only the exact set of codes or the for and the while loops, but how the structure of the entire software is focused or how it is drafted would also be something that would be protectable as a copyrightable subject matter. Similarities in structure, sequence, and organization of a program is sufficient to support an infringement claim. So even though the literal code might not be matching of an infringer and of a software developed person who has a copyrighted work, even though the literal codes do not match, you can always uh, uh, claim for an infringement suit even if the sequence, the structure, or the organization of the program is similar to the copyrighted work. If there is similarly, if there is a substantive similarity between the file structures or the screen outputs and even subroutines, they can also be used as far as the claims for infringement are concerned. Furthermore, selection and arrangement of non-protectable elements may be protected, even if the constituent elements may not. So even if sections or parts of a code are already known in another jurisdiction, or for example, if there's another source code which is already present, and we pick up certain sections of that source code from across 5 or different source codes and compile all those in a very unique arrangement, then we can also claim for a copyright as far as the registration of the same is concerned as well. This was another litigation that happened in the US, wherein in order to determine infringements, the court had to engage in an abstract filtration and comparison test. Now, what this test essentially means is that in an abstraction test, the literal code is not looked upon as is. So the code is broken down into different abstracts, so different data structures or subroutines or functions that were incorporated as far as the implementation of the coding was concerned.
and those abstractions are then filtered based on whether those sections or subroutines or data structures are already there in the industry, are already part of mechanical specs or the hardware constraints or the functionality. And when all these are different segregated elements, whatever is part or constitutes the original work and which is not there as part of the public domain would then be compared with what is claimed to be the infringing work. So it is called as the abstraction, filtration, and comparison test. This is the test which is used in all litigations to understand and assess whether there is an infringement of a copyright which is happening or not. So it is extremely important when we file for a copyright application at the Delhi Copyright Office, which is the only office in India for copyright work. It is extremely important for us to ensure that we know which component of the entire source code is our own original work, which component has been taken from which source, and if it has been taken from a licensed source or from an open source software code, or what is the originality of that particular code. It's extremely important to point out, either through in the application itself or in our own minds, we should have a complete clarity on what is the original work that we are trying to protect. What are the rights that are awarded to a software copyright owner? Now, the rights are explained and protected under section 14A and 14B, wherein in the 14A is relatively a restricted right, wherein the right of a copyright owner is to sell or give on commercial rental or offer for sale for commercial rental a copy of the software program. Section 14B covers the protection or the rights in a much larger manner, wherein it says that the copyright is protectable for everything, including reproduction, issuing of copies, making any film, any adaptation, any translation, any modification. So if somebody picks up a software source code which is made in a platform C++ and translates that exact same logic and sequence of implementation in .NET, he would definitely be translating that entire work into another platform and would definitely constitute infringement of the same copyrighted work. At the same time, if somebody in a different context of, for example, a movie, somebody writes down the lyrics for a movie or song, and if actually somebody copies that and sings that song without the permission of the copyright owner, he will constitute to be infringing on the copyright of the original person. What are the legal requirements for filing? There are two requirements when you file for a copyright application. Wherein the first requirement for a copyright has to be that the work that we intend copywriting has to be original. We have to be able to prove that there
Sorry
is
for
no
interrupting.
existing work.
Again, your voice is breaking.
Okay, I mean I can just try once again because I'm not even moving from my seat. Is it better?
Um,
Hello?
Hello?
Yeah. I mean I can change the volumes and then reset it again. Is
Yeah,
it better now?
it seems better now. Yeah.
All right. I'll then fix this configuration. All right. So I was talking about the requisites for filing of a copyright application, wherein the first requisite is that it has to be original as far as the work is concerned. We have to be able to prove that the source code that we have and that we intend copywriting is not a part of an existing source code, either in the form of a licensed copy or source code that we have picked up from the internet from any specific source or a website, or it is not part of an open source software as well. Our requirements are not very strict and complex. Once that we have proved that it is the work that source code and then submit it at the Copyright Office for submission. We have to submit 3 copies of the work. Even if we are submitting the entire copyright source code in a software CD, we have to submit 3 copies of it. A lot of companies use the same source code and keep on improving on it, especially the product companies, over and over again across years. In that particular case, for every year when we file for a new copyright application, we need not always originally have to include the copyright subject matter that we have protected in the last year. So if it's not an essential component, so if you can extract out the original part of the source code that you have drafted for 2011 and that you intend getting copyrighted from what was protected in 2010, then only the substance or only the subject matter that we have for 2011 can be put across to the Copyright Office, and we can submit it at the Copyright Office in that particular sense. Alternatively, we can also submit, if desired, the 2010 and 2011 source codes together at the Copyright Office once again. The fees for filing a copyright application is 50 rupees. We have to file certain legal forms, one of which is the primary of which is Form 4. We have to take a no objection certificate, which is the NOC from the creators. So in case the applicant for the copyright work is a company and there are multiple people who work with that company, then in that particular case, the employees of that company who are part or who are responsible for building up that entire source code, we have to take prior permission from the employees along with and through a no objection certificate, and then file the copyright application in the name of the applicant. It is also important to understand that if you already have an employee-employer agreement in place, in which the agreement very clearly
Hello?
states that
Tarun,
yeah,
your voice is absolutely not clear. People are not able to hear you properly. Can you please check the microphone setting, etc.?
I'm trying my best. I'm this is the maximum that I have. I in fact have the best of the internet also that I can. Hello.
Hello?
Yeah. Is it a little better?
It's better now, but when you start speaking, then the voice breaks a lot.
Okay. Should I continue once? Should we try once again? Then in that case. Hello.
Yeah, please go ahead. Thank you.
All right. We have the no objection certificate called as the Form 4. Form 4 is what we have to fill along with the applicant details, giving details of when the work was created, whether the work is published or it is unpublished, what is the title of the work, what is the language. We have to for software copyrights, the language would obviously be English, and the class and description of the work would be literary. Software work comes under literary classes of work. Is the work to be registered an original work? And so this statement is called as the statement of further particulars, in which we have to give all these further details. And these 3 forms, statement of further particulars, statement of particulars, and the Form 4, all these 3 forms have to be filled up together for filing at the Copyright Office, along with the work that we intend getting protected. That which can, as I said, either be a printout of the entire source code, or can be written down in an object form or a binary form, or the source code form on a CD, and can be submitted. This is how a registered certificate, a copyright certificate, looks like. it is this is the class in okay, sure. Yeah, I'm saying that page only is not open. I think it is. Yes, I think I'm joining the webinar. Let's see if it's better. Hello? Hello?
Yeah. Yeah. Please continue.
Yeah, is it better now?
Yeah, it's better.
Is it okay? Let me know if it's not better again.
It's much better now. So please continue.
Okay. We were talking about copyright infringement. I'm very sorry for the inconvenience caused. Some problems in the internet itself, I guess. Copyright infringement is covered under Section 51 and 51A and 51B of the Indian Copyright Act, wherein it very clearly says that if anybody without the explicit authorization of the original creator of the copyright work tries to use the copyrighted work, he would be liable for any infringement action, and he will be liable for any kind of damages or accounts of profit that the person would be making on the copyrighted work. We will go into more details of it going forward. Section 52 of the Indian Copyright Act says that following subject matters would not be considered as copyright infringement, wherein the 52A says very clearly that in case the copies and adaptation of the computer program is being made by lawful authorization of the creator, then in that case it will not be considered as copyright infringement. As far as 52AB is concerned, it states that obtaining essential information for operating interoperability and independently created computer program, provided such information is not available. So if somebody can prove that the program that was created by him was completely independent and does not work interoperability with the copyrighted work, he would not be liable for any infringement action. 52AD also very clearly says that if we use a copyrighted work for non-commercial use, even then in that case we will not be liable for any copyright infringement. What are the remedies that are available to a copyright owner for any kind of infringement? There are 3 remedies, one of which is the civil remedy, which is what most software product companies like Adobe, Microsoft, Symantec, Quest, and so on and so forth would go for in case they find out any software is being sold. Criminal offenses are covered under section 63 to 66, wherein 1 to 3 years of imprisonment and at least 1 to 2 lakhs of damages and seizing of infringing copies also happens. And otherwise we can also, there's another dispute resolution which can be taken before the registrar, wherein the copyright holder may request the registrar of the copyright to stop importing infringing copies and confiscate all the infringing copies in that sense. The most popular or the most commonly used medium for dispute resolution in this case is the civil court, wherein in most cases the software companies take the infringers, whether they are individuals or whether they are corporates, they take them to the civil courts, they ask for an ex parte injunction order from the judge, in which case is very clearly proven that the presence of the defendant in that case or the potential infringer is not there, and then once the ex parte order is taken, the defendant's premises are infringed, or they are directly raided by the plaintiffs and the local commissioners appointed by the judge. And once the local commissioners do their investigation, they come out with a report stating that out of so many computers, these many computers had which all unsolicited or copyright infringed copies or piracy copies or non-compliant copies. And then the complete report then goes to the civil court judge, and then the case carries on as far as the infringement of copyright work is concerned. What are the disadvantages of copyrights over patents? Now copyrights, although look to be a very strong right, because they only protect the expression and not the functionality, any company, if it develops the same functionality that is already protected by a copyrighted source code, if another competitor implements the same functionality by a different expression of thought, or by a different source code, or by a different implementation, he would not be infringing on the copyrighted work of the original author. So patents, on the other hand, protect the functionality, and in case of patents, irrespective of which source code was used for implementation. Yeah, so in case of patents, irrespective of what source code was used for implementation, because patents protect the complete functionality and not the source code, in that case, we are the patents protect are much larger in terms of the entire protection. Registration of copyrights is very inexpensive, because the government fees is only 50 rupees, and patents, on the other hand, are very hello. 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 Yes. So because copyrights are very inexpensive, the registration of copyrights is a much widely used concept than patents at the present moment. For patents, the Indian Patent Act does not allow patents to be granted. Furthermore, because copyrights fall under the Berne Treaty, if a copyright, as I discussed earlier as well, as a copyright, if filed only in India and if it gets registered, the copyright applicability remains global. So all the countries which are part of the Berne Convention, which are about 135 countries, would the copyright would be protected in all those countries. Whereas in case of patents, patents are only protected, they are only protected in the countries in which we protect that territory. Some of the recent case laws as far as copyright work is concerned, infringement matters are concerned, was one of which was in Microsoft versus Yogesh Popat, one of the largest software copyright infringement cases that have happened till date, in which a fine of 2 lakh rupees was granted against Mr. Popat. Mr. Popat, as a history, was working in Delhi and was in the business of selling computer softwares and hardwares, and because all those hardwares were the original Windows was not being implemented or installed on the computers that were being sold by him. All the computers in the that were being sold, or the laptops that were being sold, had unsolicited or unlicensed copies, or pirated copies for that matter, of Microsoft or of other softwares like Adobe, Quest, and so on and so forth. Furthermore, there were cases like Microsoft versus Deepak Rawal, Microsoft versus G.V. Rao and others, in which the same case law prevailed and the same sequence of events happened, wherein all these people were individuals and they were selling hardware and software, when the software, when put on the hardware, was not a licensed copy from major software manufacturing or producing companies. There are a lot of other companies like Adobe, like Autodesk, which have now come into the same business. One very recent case that happened was of Autodesk versus Mr. Prashant Deshmukh, wherein the case was filed against the defendants for a large scale of unlicensed and pirated software that was installed and sold by Mr. Prashant Deshmukh and his allies, and the damages awarded were to the tunes of 20 lakh rupees. And it was the same sequence of event wherein there was an ex parte injunction order which was taken from the judge. The company or the premises of Mr. Prashant Deshmukh were raided. They were the copies, unsolicited or non-compliant copies of the software, were seized and produced as far as the local commissioner reports are concerned in the court of law. And eventually, during the proceedings, Mr. Deshmukh lost the case and was awarded was forced to pay rupees 20 lakh as damages. This is another case law that I wanted to discuss. In summary, I'll come directly to the point in terms of what the impact of this case law was. Pine Labs was the plaintiff in this company. It was a software development company. There was another hardware terminal hardware development company called as Gemalto Terminal. In this particular case, Gemalto had hired Pine Labs, wherein the defendants had hired Pine Labs for development of a small software program. In this software program, the entire software was eventually built up for Indian Oil Corporation, wherein both the plaintiff and the defendant were directly working as vendors for Indian Oil Corporation. The plaintiff, as I said, was a software company. They were liable and they were expected to build software which would then be put on the hardware of Gemalto, which was the defendant, and then be shipped to Indian Oil Corporation. What happened in this case was that once Gemalto implemented the entire application and put it on the IOC, which is the Indian Oil Corporation's system, using Pine Labs software, Gemalto also approached another company, which is Hindustan Petroleum Limited, and instead of using Pine Labs software, they gave that entire software code that was alleged software code implemented by Pine Labs to another company, which was another defendant in this case, company we can call as A. Now, in this particular case, Pine Labs then sued Gemalto, stating that the entire source code that it had written down was its own copyright and was not the copyright of Gemalto. However, point 10 of the slide says very clearly that there was a agreement that was signed between Pine Labs and Gemalto, in which it was very clearly said in point number 7 that Pine Labs would be assigning all the intellectual property developed through this project to Gemalto, which was also referred to as Exalto as far as the company name is concerned. Under this clause 7.1 of the agreement, because the 7.1 clause did not mention any time limit of till when would all the intellectual property rights be transferred, there was no mention of the time period or the territory of protection. And therefore, the plaintiffs said that because the time period, if it is not mentioned, the Copyright Act mentioned the protection and the assignment, it can only be given for a period of 5 years, and the territory would only be restricted to India. And therefore, Pine Labs had said that because the source code of Pine Labs was given to the other vendor A by Gemalto, after 5 years, all the copyrights was vested back into Pine Labs, and therefore there was a copyright infringement on the software that was developed by Pine Labs. Directly coming down to the judgment in this particular case, it was very clearly held that there were two issues to be decided.
Mr. Tarun, we cannot hear you.
Can you hear me? Hello?
Yeah, you are able to hear you now.
I will then try and conclude and then come down to questions. Maybe that will be more
Right, right.
better as far as
Sure.
I will directly come down then. Perfect. I wanted to touch base with the end user licensing license agreement a little bit. Now, EULA is a legal contract between a user and the software publisher. That spells out the terms and conditions for using the software. Now, for example, whenever we install the software on our computers or desktops, then there is a link which says that I have to accept the terms and conditions of the software publisher, and those terms and conditions is what is the end user license agreement. Those agreements could talk about a number of different processes or thoughts that the publisher has in mind, which he would want you to comply with while you are using your software. Now, how end user license agreement works is that it can work in multiple formats. One of which could be that you can be expected to click an I accept button while installation. You can also be expected to open a shrink wrap software package or breaking of a seal. Now, all those instances, even if they are done physically, are also construed as that you are accepting the end user license agreement. Installing of an application, even using of an application which does not say, very clearly state that if they do have a terms and conditions clause, then if you use the application, even if it does not talk about I accept, we are bound to follow the terms and conditions that are there as part of the EULA. We can very clearly refuse to accept the terms and conditions of EULA, but then we cannot legally use the software as well. EULAs are legally binding. A number of influential courts have upheld the legalities of EULA, and therefore we have to enter into legal agreements when we accept their terms. There is no denial later on, and we cannot make those arguments that we did not go through the entire EULA from our own side, or that the permissions that they had asked for, the data that they would be seeking from our computers, or from the manner in which we use the internet, all those things, if we have accepted while we are using their product, then we have very clearly accepted the entire EULA in totality. EULA characteristics. EULAs can force you to agree on certain conditions, as we did say. It may require us to monitor the internet activity. So the software publisher can put any clause that he wishes to put in the EULA. In case the publisher wants that he would want to monitor the internet activity of the user while he is using the software of the software publisher, he can absolutely put it across in the EULA without any problems. And once the user starts or accepts that entire EULA, the entire internet activity of the user would be shared, and the sharing of computer resources, all those things can be put across in the agreement as well. EULAs can limit your ability to sue for damages. So in case the user of a software suffers from a damage or a loss in business while using the software of the software publisher, in case the EULA or the license agreement says that you cannot sue the publisher for any damage, we cannot do it irrespective of what the extent of those damages is to our particular case. EULA is from a publisher's perspective. EULA is always drafted in such a manner so as to protect the interest of the licensor. It is not there to protect the interest of the licensee, because it is for the user to understand and see that the kind of damages, the kind of infringement actions, the kind of liabilities that the publisher takes on him, are they worth that attention or not. Following points can be considered in the agreement. There could be product specifications of what the product is all about. The EULA could talk about the kind of license which is being given. Is it a non-exclusive license, or it is an exclusive license? If it is non-exclusive, in which all territories the license is there, and so on and so forth. the EULA could also discuss and disclose information about the duration of the license, the grounds for termination, the legal jurisdiction in which, if there is a dispute, where would the jurisdiction be held. So in case if it is Microsoft, and if we suffer from a damage, or if we want to actually take any legal action for a wrong that has happened to us by using of the software of Microsoft, if the EULA says that all the disputes would be settled in Redmond, then we will obviously have to follow and abide by that jurisdiction and do the entire proceedings of the litigation in Redmond itself. Now, what does EULA typically contain? As we've already discussed, they contain all the licensing agreements. They talk about what kind of a license is being given to a user, how many machines can he work that license on, is it a multi-user license, is it a volume license, and so on and so forth. It also talks about the warranties, which is basically a disclaimer of a warranty stating that even if the software is most likely to work on the user's machine, there is no guarantee that the software would still work. So if it does not work, the user cannot take any legal action against the software publisher. What are the laws? The laws would typically be like where the jurisdiction of a dispute would be, what kind of arbitration would there be, if any, what kind of civil actions can we take, if any, what are the liability of the software publisher in case of any mishap that happens in case or in duration of the entire use of the software. What are the potential concerns for the EULA users? Now, it is extremely important for the EULA users to make sure that they read and go through the entire agreement very, very carefully, because there are certain software publishers that say that as part of the EULA agreement, they would be entitled to monitor the internet activity, or even sometimes personal information that we put in multiple forms or websites or social media. They can also be accessed, and then there can be no legal action that can be taken against the particular company, because it is the liability of the user and it is his responsibility to go through the entire agreement. The EULA users also allow software publisher or third parties to use computing resources. So this could be another agreement that could, another clause that could be a part of the EULA. It could also hold the user onto the terms relating to governing third-party softwares. Now, if the software product that we are using also uses another third-party software component internally, then the EULA of the major software publisher could make it compulsory for us to also accept the EULA of the third-party software component, which is a part of the software publisher that we are talking to directly as well. So it's extremely important for us to understand of what are the third-party components being used and what are the EULAs of those respective third-party components, which are also available online or as part of that agreement itself. Therefore, the potential suggestions from our side would be that it is extremely important, especially for software companies which are using another set of software products. It's extremely important for them to read the EULA, because they will be using not one license but multiple licenses, maybe volume licenses, multi-user licenses on multiple machines. So it's extremely important for them to read the EULA before they install and use it. It is extremely important to consider who the software publisher is, what is the association that it has in the market with what kind of third-party component manufacturers, and so on and so forth. There are a lot of software publishers wherein while installation they allow or they want us to prompt for different firewalls that need to be talked as well. So if a software publisher typically wants us to accept and bypass a certain firewall prompt, and if we accept that, then any information that could come through that firewall which might not even relate to that software per se would also be something that we will be liable for and not the software publisher. Potential concerns of EULA users, it is extremely important, especially for us, to make sure that the free softwares are taken care of. The EULAs are very, very well validated. Extremely important for us to scrutinize and evaluate any EULA that requires us to monitor online activity. It is also important for us to ensure that when we are evaluating the effect of a EULA on a security or privacy of a computer, we have to make sure that what is ethical for us, what is not ethical for us, and there are a lot of governing bodies, regulatory, non-regulatory bodies which govern the URAs, and in case we do find out that there were some unethical clauses that were put in the license agreement, and then in that case they can also be reported to such bodies as well. I will now come directly to free and open source software and maybe speak for 5 minutes on this topic. Now, free software is a software which both the terms are interchangeably used a lot of times, but primarily the difference is that the free software can be used without any consideration being given to the software provider. Open source, on the other hand, shares the source code, and in addition to using the software, it also allows the users to modify and further customize the software. So free softwares might not always give you the source code. They might only give us the binary or the executable file that we can use. Of open software, on the other hand, along with giving the software, they give you all the source code so that we can modify, further improve, or customize the source code based on what our requirement is all about. There are 3 types of licenses which are granted for open source software. One license is called as the permissive license. Now, it's extremely important for us to understand that open source softwares are open source in the sense that they give you all the source codes. Now, what is the derivative work in those source codes? Till what extent can we improve on? What is the level of copyright work that we can include and take onus of? Can we further license commercially the products that we have built on open source software or not? So these are all things that get governed by these 3 types of licenses which are given by the open source software. The first is a permissive license. Permissive license allows the open source software to be incorporated into a software license downstream under closed source terms and in binary form only. So in permissive licenses, only modifications all the modifications can be kept private if desired by the copyright owner. So if the original person who had given the open source software was X and he had given it to a person Y, then Y, if he develops further improved or a modified software using the open source, he can keep the entire source code with himself and only be liable to share the binary, and that is it. Such softwares, examples of such softwares are Apache, BSD, and MIT. There are certain weak copyleft licenses. Then the weak copyleft licenses are those licenses which explicitly permit incorporation of copyleft covered software into a larger binary executable licensed copy under different terms. Now, which is, for example, Mozilla Public License. It is considered as a weak copyleft license because the requirements for modification can be made available in source form under the same license and can be avoided by placing modifications in separate files. So we do not actually have to, the difference between permissive and copyleft is that in copyleft, both these copyleft licenses, we have to share the source codes. There is no doubt. But in the weak copyleft licenses, we need not share the source code along with the software itself. We can keep it alongside and share it in a separate file or to any other separate medium. But in a strong copyleft license, we have to give the complete modified software along with the source code to any further person who would want to further develop and improve on it. And that same person, if he further improves on the same license, he would again have to make sure that he again gives only a strong copyleft license, and he cannot then give a permissive license to another company. What is construed as a derivative work on an open source software? A mere aggregation of an open source software with a closed source software together does not make it fall under the broadest definition of a derivative work. So if there is an original source code that a person or an author has written and he combines it with the open source software, it would not be considered as an open source software again, and therefore it would not be a work of the open source software. Extremely important to see the third point, which says that only those modifications which are made to the open source software would be considered as a derivative work. So only if we use the same open source software as is, and then internally we make more improvements on the same software so that the functionality does not significantly change, then in that case is only when it would be considered as a derivative work. As we discussed, the abstraction, filtration, and comparison test would again be implied here to make sure that what are the components which are original, what are the components that were there in the public domain, what are the components that are always there as part of that platform that we are coding on. And once we identify what the original work is, that work would eventually be compared with the work under contention. This is the last slide that I'll be speaking on. Points to be considered for companies using the open source softwares. While using the open source software in a software that would eventually be commercially licensed, it is extremely important to know the in-licensing obligations. So we have to know whether it is a permissive license, or is it a weak copyleft, or is it a strong copyleft license. We have to understand the definition of the distribution. So every open source software would have a definition for what distribution means, and that distribution clause would talk about what are the ways and the modes in which multiple distributions can be made by the company or who is building and improving or modifying on the same source code. Now, if a software developer combines the open source software in such a way that pieces of the software licensed under different open source licenses would be considered as one large work, then conflicts in the open source licenses may actually prevent the work's distribution in totality. So if the person who's improving or using the open source software and then making his own software using that open source software code, then in that case it could potentially be considered as a derivative work, because largely he's basing the entire algorithm on this open source software that he has, and therefore further licenses cannot be granted in the manner of a permissive license or on a commercially as a proprietary license that companies like Microsoft or Adobe typically give. The last point is also quite self-explanatory. It says that once the open source software is incorporated into a corporation's product and distributed, the corporation is vulnerable to the threat of termination of the OSS license if the terms of OSS are not met. So we have to understand what the terms of the open source license or the open source software are. We have to understand what the distribution clause says. We have to understand what kinds of improvements can be done, to what extent can we add more code to it, and to what extent and try and answer certain questions that we have now.
Yeah, the questions are already shared with you.
Yeah, just 1 minute. I'm reading the first question. This is from Shubhangi Walke. I am reading the questions once again. So the first question says that in case of a company having hired equipments from a vendor who will provide desktops with licensed OS and MS Office, in an event of a Microsoft license audit, if the vendor has not provided authenticated software, who will be responsible, the principal vendor or the company? Now, Mrs. Walke, the entire mandate in this particular case would be dependent on what agreement has the company signed with the principal vendor. Now, if the liability of any infringement or any unsolicited or non-compliance, if found later on, lies on the company or does not lie on the company but lies on the principal vendor, then obviously it would be followed accordingly. If there is no such agreement between the principal vendor or the company, then because the complete assignment of the project is given by the company, the complete onus lies on the company in terms of making sure that whatever computers are being used on its premises are compliant as far as licenses are concerned. Then in that case, company would be liable for all such damages. But in most cases, it would be very clear clearly, it should be and would be very clearly written down in the agreement in terms of who will be liable in such a case. And whatever that agreement clause says in terms of who holds the right or the liability in terms of any threat of intellectual property, any infringement action on copyright infringement, it would be taken forward accordingly. In case this is the same question that was repeated, in case of a company does not use a registered logo and uses a different logo, are there legal implications? This is again by Mrs. Shubhangi Balke. Absolutely, ma'am. However, this is not related to copyrights but on trademarks. But you are supposed to write R with the circle, which is for the registered mark, only for marks that you have got the registration for. Now, for example, if Google has got a registration of a trademark for Google, which is the first 3 letters written in green and the last 3 written in red, then in that case, if Google itself writes Google with the first 3 not being in green but being in black, and it writes R, it is absolutely a falsification and deceptive representation of the registered mark, because that is not what is registered. So it's extremely important to ensure that you are only protected for what you write down. You are only protected for what you register as far as your logo is concerned. And if you do not, if you use a different logo and use R along with it, then you are not protected, and it come into the deceptive misrepresentation of your mark. But at the same time, if the logo that you're using is different, but you are not using R along with it, but instead you are using TM, then in that case there is no such potential threat in this case, because then you are not falsifying the fact that it's a registered trademark. What is the third question is from Mr. Vishnu Kumar, which says that what is the difference between copyright for software and getting commercial license? The copyright for software would typically be done by the author or the applicant or the owner of that copyright, which is for the computer program. However, getting a commercial license would always be done by the licensee. The licensor in such an agreement, in such a license agreement, the licensor would be the copyright owner, in whose name the copyright is there. On the other hand, the licensee would be the person who's bought that product or bought that software and has therefore taken a license. He's called as a licensee. So this is the difference between a licensor in whose name the copyright is there and the licensee who takes the license. Now, the exact difference between copyrights and patents has again been asked by Mr. Vishnu Kumar. The difference is quite clear. Copyrights only protect the expression of thought. It only protects the source code, as I said. So they only protect the literal expression of your thought, but they do not protect the functionality. So if, for example, the functionality of going through different presentations in a PPT is written in a software code X, and if somebody implements the same functionality of going through or browsing through multiple slides of a presentation through another implementation Y, then the source code of Y or the author of Y would not be infringing on the copyright of X. But had X, who's the owner of that copyright, also got a patent on the manner in which the browsing happens, then irrespective of what the implementation of Y would have been, he would have always been infringing on X. Public performance right is a completely different copyright, which is a completely different subject matter that comes into the performance in terms of artistics and the artists and the magicians and other set of creators, creative people who give representation or who make a significant contribution in terms of putting across a show in the public, and that is what you get a right for. So if, for example, I put across a magic show on a stage, and if that is a recorded show, then nobody else can copy my magic tricks without taking my prior permission. Those are what the rights are given for. They are again a part of the copyright itself, but it's a different set of rights, nothing related to software rights. Is there any copyright against free content like preparation tutorials available free on the internet? This is asked by Mr. Kunal Bindal. Mr. Bindal, it all depends on the owner of that copyright. So if he very clearly says that the preparation materials or the tutorials that he has written down are absolutely not something that he is having a copyright over, or he gives a non-exclusive open license to everybody to use it for commercial and or for non-commercial purposes, absolutely there is no copyright that he has. But he would still have the right to later on change, in terms of what right he gives, what right he amends, and so on and so forth. So it all depends on what explicitly has he written down as far as that granting of rights or granting of a license is concerned to the public at large. A lot of times we believe that the images that we download from Google Images or from other sources are not copyrighted, but Google itself does not store all those images, and they're again taken from multiple sources, and those multiple sources maybe in certain cases have those images as copyrighted images, and therefore it is extremely important for us to understand and make sure that that we do our proper due diligence before downloading and using those images. So just because those are preparation tutorials which we might be using for non-commercial purposes are there freely available doesn't mean that it's a right that is given all across to everybody across the globe to use it non-exclusively without seeking any prior permission. There is another question from Mr. Karthikeyan V. It says that he's a game producer and has a lot of game concepts. How can I copyright it? And how will it help me? How will it help you? So as I said, copyright is not a right that you have to register with the Indian Copyright Office. The moment you express your thoughts and put it across on a piece of paper or on your computer, your complete copyright is protected from that day itself. The only reason why you would want to copyright it with the Indian Copyright Office is so that from a legal perspective, there is no challenge once you register your copyright and you have a legal date associated to the work that you had created. Because if you do not file for a copyright on 5th of 17th of February, for example, today, then if there is a future litigation that happens on the book, on the implementation of the video games or the concepts that are there for the video games, then in that particular sense, you will have to establish that you had thought of and expressed those concepts on 17th of February. However, if you go to the Copyright Office and file it, then you have an authentic legal proof that this is the date from which I had protected my entire copyright. And therefore, the only difference why you would want to protect it with the Copyright Office is to get the legal date with yourself, which would not be challenged and which cannot be challenged going forward. But on the other hand, if you do not protect it with the Copyright Office, it can be challenged going forward by anybody who is interested in taking a license and not paying you any royalty or any upfront payment. How can you protect it? You can absolutely, all the game concepts, you can conceive it, write it down as far as the concept is concerned on a piece of paper, represent it through multiple graphical implications of how the game would actually be played, what would the rules be, what would be the terms and conditions be, how would a person win, lose, what the concept is, if there are graphics involved, so on and so forth. You can just draft a concept note, print it out, put it across with the forms that we discussed about, and file it. This is how you would protect your copyright. I think I've answered all the questions. If there's any further questions, I'll be very happy to take them.
All the questions are answered. We'll wait for a minute if there are any more questions.
Sure. Again, I'm taking this opportunity. I'm extremely sorry for the internet connection that went bad off and on, and there was something wrong with the internet today in our office, and I apologize deeply for it. But my complete email ID and the complete information is there on the screen, and if there's anything that I can be of assistance as far as any communication is concerned or any clarification, I'll be very happy to be directly called up, and we can absolutely have a discussion so that you have complete clarity on any further question.
Okay, I think we can conclude the session now. Further questions can be asked on techgig.com as well.
Sure.
Thanks, Mr. Tarun, for your informative session on copyright compliance and end-user license agreement. It was indeed an enlightening session. I would also like to thank our participants for their support in making this webinar a success. The recording of this webinar will be available on techgig.com by tomorrow. Gentlemen, TechGig announces a new webinar series on Android development. The first session in this series is happening on Monday, that is 20th February at 3 p.m. Topic for the webinar will be Android architecture and application fundamentals. We will be having Mr. Vivek Arora, manager at MySpark Technologies, as our guest speaker. So see you all on Monday at 3 p.m. Have a nice day. Thank you.